nice surprise. Good to see you.
Likewise, Senator. It's good to see you too. It's good to
Mr.
see a
Porter,
lot
I
of
feel
old
like I
friends
haven't
here.
seen you in ages. Now that they booted me off of finance,
You miss me.
I miss all of you.
Yeah.
All right, I miss Senator McCormack too.
All right.
We're
well,
neighbors.
Good to see
We
Senator
won't-
Westman again. I never get a chance to miss Senator McDonald.
We are live.
All right. So good morning, everyone. It is Tuesday, April 27th, 10:31 a.m. And this is the meeting of Senate Natural Resources and Energy. We are starting the morning with spending some time with folks from Global Foundries and the department and our own council to so that people on this committee, which writes energy policy, will be aware of some developments in the energy world. And that is, in particular, that Global Foundries is petitioning the PUC to create a new form of utility here in the state of Vermont. And so it's going to, it's clearly of interest to this committee to understand what that new form of utility is and how it relates to the current body of utility law and energy programs in the state. So with that, thanks very much to Mr. Reeder for coming over this morning. And the floor is yours. If you could introduce the committee to the concept that Global Foundries is bringing forward, that would be helpful. Thanks.
Thank you, Senator Bray, and good morning, everyone. For the record, my name is Greg Reeder, and my title at Global Foundries is Principal Member of the Technical Staff. I'm a registered professional engineer by the state of Vermont, and my primary responsibilities is the oversight of the engineering, operations, and maintenance of the electrical infrastructure at the Essex facility at Global Foundries. What I'd like to do is share, I have a short presentation I would like to share with you to go through the overview of our proposal. So let me see if I can share this.
Great, looks good.
So I'm assuming everyone can see my slide.
Yes, sir.
Okay. So first, I'd like to thank the Senate committee in giving me the opportunity to give a brief overview detailing the self-managed utility proposal, and would like to categorize this overview in 3 questions. One is, what are we doing? 2 is, why are we doing it? And lastly, how are we doing it? At the end of the presentation, I can answer any questions the committee may have. So let's start with the first question, what are we doing? Following a long collaborative process, Global Foundries, Green Mountain Power, and Velco have reached an agreement on the proposal for Global Foundries to become a self-managed utility, and we filed a petition for the Certificate of Public Good with the PUC on March 17th. The SMU proposal allows Global Foundries to be more globally competitive and creates parity across all of its manufacturing plants. Importantly, it protects existing manufacturing jobs in Vermont and improves the prospect for further investment by Global Foundries in Vermont and future growth. So let me give you a little background on Global Foundries. Global Foundries is a semiconductor manufacturing plant headquartered in Malta, New York. It has about 16,000 employees worldwide. And in 2014, Global Foundries acquired both Fab 9, which is what we refer to as the Burlington or Essex Junction facility, and Fab 10, which is the East Fishkill plant from IBM. In addition, Global Foundries has plants in Malta, Dresden, Germany, and Singapore. And these plants are all manufacturing chip plants, and they produce these chips on 2 different size wafers, 200 millimeter wafer and a 300 millimeter wafer. Burlington is a 200 millimeter wafer manufacturing plant, and the other 200 millimeter wafering manufacturing plant is in Singapore. One item to note regardless of the size of the wafer the chips are being produced on, this technology can be manufactured in any one of these sites, regardless of the size of the wafer. So a little bit more detail on the Burlington site in Essex Junction. The market segments that the Burlington site is in the mobile, wireless, and infrastructure, automotive, industrial, and medical fields. In fact, most likely one chip that's produced out of this plant is in 85% of the cell phones worldwide, which that accounts for probably about 43% of the Vermont state exports footprint. In addition, we are the largest private employer in the state of Vermont with approximately 2,200 employees. And we actually, the site is actually on two campuses, one in Essex and one in Williston. The self-managed utility proposal is only going to be including the Essex facility. It will not include the Williston facility. Now, the manufacturing at this site is very power intensive operation. We're running this plant 24 days a week, 24 hours a day, 7 days a week, 365 days a year. We actually consume more power than the entire city of Burlington, and we account for approximately 8% of the state's loads. What is unique about this plant is we have two independent 115 kV transmission lines that provide power to this site. And GlobalFoundries owns, operates, and maintains its own distribution system here at this site at an approximately cost of about $3 million a year. We have a dedicated team of engineers and technicians that are solely responsible for the electrical distribution system and providing reliable power to its manufacturing operations. So let me try to answer the next question. Why did we do this? The primary issue is VAD9's annual electric costs is nearly 50% of the operational costs of the site to support manufacturing. In fact, the unit cost is approximately 90% higher than GlobalFoundries' New York sites. Our goal was to close this cost gap in New York, which allows VAD9 to become more competitively both internally and externally worldwide. In addition, it creates parity among all of the GS plants worldwide. As I stated earlier, in our analysis, GF can move their technology to any one of the sites, whether it's New York, Singapore, or Dresden. In addition, GF is risk tolerant on purchasing power on the open market. This is demonstrated with GlobalFoundries' expertise and experience in grid management and the purchasing of energy on the open market in the other similar sites in New York and around the world. With this self-managed utility, we would be improving the capital expansion and growth opportunities specifically for this site in Fab 9. What I'd like to take you through is a little bit of a timeline since GF acquired the sites from IBM in 2014. There was a MOU term contract signed by GMP that basically froze GF's rates until October 2017. GF started the negotiations with GMP in March of that year, and effective January 1st, 2019, the PUC approved that term contract until September 30th in 2022. What was very important about that term contract, in addition to freezing the rates for GlobalFoundries, it allowed a collaboration process both for Green Mountain Power and GlobalFoundries to work on a longer term solution to develop a more viable energy portfolio for GlobalFoundries. In December 2019, both GMP and GlobalFoundries submitted a report to the PUC detailing various alternatives that we worked on, including the single customer utility or virtual utility as one of the alternatives for further consideration. In the last 2 years, in 2020 and 2021, that alternative actually developed into what we are calling today the self-managed utility model. And that MOU was signed between 3 parties, Global Foundries, Green Mountain Power, and Velco on March 12th of this year. And then on March 17th, Global Foundries filed a petition for a certificate of public good. So how are we doing this? As I stated, since 2019, Global Foundries and Green Mountain Power have worked through a collaborative process to find ways to eliminate the piecemeal term contracts and create greater stability and sustainability for Global Foundries in the long term. In addition to remaining in Vermont and providing and not impacting the Vermont customers and improving the Vermont economy as a whole. This solution is unique to Global Foundries for a number of different reasons. One is the amount of power that we consume is extraordinary for our process. Number two, it has direct connection to the 115 kV transmission system and owns and maintains its distribution system, as I stated earlier. The self-utility model will allow GF to manage its own distribution system and supply its own load. They'll remove Global Foundries from GMP service territory, retail load, and service obligations. And over a 4-year transition period, it will allow Global Foundries to purchase energy, capacity, and the renewable attributes through a PPA that includes transition fees to offset Global Foundries' stranded costs during that time. In addition, Global Foundries will not sell any service to retail customers or recover any operating costs from the ratepayers. So the benefits of the self-managed utility, again, it allows GF to direct its own purchase to satisfied load through a wholesale market, consistent with its own goals, timelines, and strategies in order to manage risk across GF manufacturing plants and enhance its global competitiveness and improve the prospects for growing in Vermont. In addition, we will remain strong. Global Foundries will remain a strong manufacturing company in Vermont and contribute to the state's economy. Maintain Global Foundries as a wholesale transmission customer through Velco to benefit all these electric ratepayers in Vermont. It allows GF's corporate philosophy to be worldwide industry leader in clean energy standards and continue to be recognized for its environmental sustainability. And lastly, GF is making these decisions today to grow the business worldwide. And the SMU enables Fab 9 to be competitive and grow in Vermont. So with that being said, is there any questions that I can take from the committee?
Thank you for the presentation, and I'll wait till you pop down end screen sharing.
Okay. There we go.
Great. Well, a lot easier for us to, now we can see each other. I know we're going to lose Commissioner Tierney at 11, so I don't want to rush on to the commissioner, but let's pause and see, are there any committee questions for Mr. Reader right now? Senator McDonald, and you are muted, sir.
I didn't understand what will manage its own distribution system means. Does that mean after the electricity gets to the plant or from the source of the electricity to the plant?
Actually, it's a little bit of both. Right now, we manage our own distribution system from starting at the 115 kV transformers and stepping the power down to the distribution voltage, which is 13.8 kV, and then managing that entire distribution system within the plant. We have approximately 140 substations within that plant that step the power down to its utilization voltage, which is either 480 volts or 4160. Does that answer your question, Senator McDonald?
Oh, that you've been doing that right along. So what's the new part of this?
So the new part would be procuring our own power on the open market. That would be the new part. Right now, Green Mountain Power supplies that power on the open market.
Okay, thank you.
Yep.
Okay. Any other committee questions? And I suppose, one thing that the committee hasn't looked at, and we did not, but I'll get a copy and distribute it to members for after the meeting, so that people will be aware. Anyone who's in the committee and interested in the details probably it'd be helpful to read the petition. So, Mr. Reader, could you send after the meeting over a copy of your petition to the PUC, and that will help people know more precisely what kind of details are being put on the table in terms of the possibility of working out such an arrangement and the implications around energy in the state. So great. Well, thank you for that overview of the project. So now we have that piece in place. I wanted to turn next then please to Commissioner Tierney and Mr. Porter to talk to us about the department's role in this. So since this is a novel situation for us, someone proposing a new utility, could you give us from, assume nothing. And so when that comes through the door, what is the department? How do you roll into action, and what kind of things do you think about, and what's the process you're involved in?
There we go. Thank you so much, Senator Bray. I appreciate that question. It is true that we have not, in my time at least in state government, which spans over 20 years now, seen the creation of a utility per se. The points of reference are familiar. For us, it's generally Title 30, which is the all-comprehensive statutory scheme for regulatory matters. And the two issues that come up are service territory and whether it is in the public good for this entity to operate and provide service, even if it is only to itself. And under service territory, we look at 30 VSA 249, I think it is, where there are several criteria that govern the alteration of a utility's service territory. And that's that's the test that GMP will have to clear here in persuading the PUC that it is in keeping with those criteria in the interest of the public and specifically consumers for this change to happen, where they carve Global Foundries out of their service territory. For Global Foundries itself, if it's to become a utility, it has to get a 231 CPG, which is the licensure for operating a utility plant and the like in the state. The PUC looks at any number of criteria that they have established through their own case law over many years. And if they do not have criteria that are suitable for reviewing this transaction, then they would exercise their customary powers as a regulating entity to fashion such criteria. The department's role then is to appraise, on one hand, what the ratepayer interest is here, and secondly, how to square this with state energy policy, because as you well know, we also have that planning role and that policy implementation role in our agency. And that's very much how we intend to approach this this case. You will perhaps recall from my testimony in front of Senate Finance that I introduced the additional consideration of Section 30 VSA 218E, which was passed a few years ago, I think in 2014 or 2015, that specifically establishes a state policy as well, the proposition that high-paying jobs, specifically in manufacturing, the preservation of those jobs is a value that is also to be factored into policy decisions in weighing such matters. So that's pretty much where we are. The department is asking those questions in discovery. How is this going to affect ratepayers? How is this going to affect the public interest? and is very mindful of the legislature's concern that the hard work that's been done in the renewable energy space over the last several years be properly weighed in the bargain as well.
Okay, great. Thank you. And I don't know if Mr. Porter wants to add anything, or maybe he can explain his particular role in this. So we'll
I'm happy
understand
to.
that.
Since we've only got June for 10 more minutes, would you rather her finish and then I can come back and kind of walk you through
Sure.
step by step what we do?
Okay, great. Thanks.
Jim's role is principally to keep me out of trouble. and my role is to make sure that we don't do anything in front of the legislature that compromises his ability to conduct his case in front of the PUC. But I'm happy to answer committee questions at this point. I really don't have much more to add to what I just said.
Okay. Senator Campion.
This might be more for the chair, and I just want to confirm this is informational for us, which I appreciate. It's really helpful, but this is out of our hands with regard to playing a role in this one way or the other. And again, I appreciate that the background, it's really important to have, but I just want to confirm the process a little bit.
Well, I think there is some. It's what our role could be has some room for interpretation, and so we'll have counsel in to help us understand what options are available for us, from simply observing to participating more directly.
Okay, thank you for that.
But I
assume
did
it's
want
just
us to,
us.
yeah, thanks for the clarifying question. And so I did want us to all start from a level playing field and just understanding the project itself, and then the process whereby the department would represent particularly the public good, which is something I'd say we have sort of a shared sensibility around trying to represent public good. Amongst other things. Okay, so I think Senator McDonald, I see your hand back up.
Yeah, the previous Mr. Reader told us what was new about the distribution side of this proposal. The last time that we were approached in the legislature to change the law by IBM, we didn't. And so what is new that now appears that the law doesn't need to be changed, and that those reporting to us appear to not be concerned about the need for a change in the statute to allow this to take place?
Mr. Chair, did you want me to take that?
Yeah, I think, I mean, I don't expect Mr. Reader to speak to what something that the former owners of the plant did or did not do. So,
oh, not at
know.
all. I just, Mr. Reader
Yeah.
was very clear in explaining the proposal, what was new. And I was hoping that we would learn what was new that suddenly put this on the horizon as apparently there's no need to change the law to do this.
Okay.
Well, from my perspective, Senator, I'm looking at the law as it exists today. I was not around in this present role that I have for the transaction that I think you're referring to. I think the last time we talked about this in Senate Finance, I had indicated that it would be best to speak with your counsel about this. I'm not aware that there is an identical case that was proposed in the past. And I do recall an exchange with Senator Pearson where I was trying to be as clear as I could be in saying that similar isn't going to cut it for purposes of reviewing the petition that's in front of the PUC. It's clear to me from your question that you perceive similarity with something that happened before. And I don't have that example in mind. As we sit here and look at this petition today, and what the PUC will be doing is looking at the petition under the law as it exists to come to a determination. It may well be that they will come to the conclusion that your suggesting that the law does not permit this. I don't know, but that's the review process that's underway now.
Could I follow up and ask Senator McDonald just one question about that?
It might be my question too. Go ahead,
Yeah,
please.
yeah. Well, before you ask, there's similar is similar and identical is identical. And so just what has changed since then is, I guess, is my question.
My point is, I don't know what the prior reference is, so I can't answer that question. I don't know what it is that you think was established that is now changed. I do know that Global Foundries is not IBM. Global Foundries is asking to procure power directly on the wholesale market. I don't know whether IBM asked to do that or not, or if they asked to do so as a virtual utility certificated under 231 or not. I just know that Global Foundries has made this petition, and GMP has a parallel petition to alter its service territory to literally cut Global Foundries out. I don't know whether IBM asked to do that or not, but those things are material facts that go into this petition that is now being weighed in front of the PUC.
So maybe I will withdraw my question and just ask someone to explain what a virtual utility is.
Well, if I could just really quickly ask, I know some years ago, and I think it was IBM, I believe was at the legislature and elsewhere complaining about the energy costs that they were paying. And I know in 2014, there was Act 199, which had the department and ACCD and maybe some others doing a study of anything that could be done to alleviate those costs. And part of that really dealt with retail choice, which was allowing an existing customer, albeit a kind of odd customer because they're so large, to kind of purchase their own power, but be a part of what they were. Is that what you're talking about, Senator, when that came up maybe around 2014?
I think you may have the correct date. Yep.
Okay. The only thing I would, and I don't remember when that was going on, and I didn't, we actually, the department issued a report on that. And I think the conclusion was at that time that retail choice was probably not in anyone's best interest. And I would probably have to defer to the Global Foundries Council. But I do think that, because I do know what you're talking about in the fact that we did the study and all, as a result of that, I do think that's a different fact situation than what they're asking for today, which is literally to become their own utility, if that makes any sense.
Well, thank you very much for your efforts.
I think one other fact to add to that is that, as I mentioned in Senate Finance, there is I hesitate to call it a precedent, but the AMIA entity is a company down in the southern part of the state, as you know, for many years had its own generation facilities, and with that, the right to function as a utility, and it distributed its energy to a variety of local customers. It also worked very closely hand in hand with CVPS at the time, so that CVPS logistically managed a number of the functions of AMIA functioning as a utility. But it's not entirely unfamiliar in Vermont to have an enterprise that is functioning as a utility for legal purposes. That is not what you would otherwise recognize as a distribution utility, like BED or Washington Electric Co-op. So this proposal is one step farther down the road in that, as I understand it, Global Foundries would have no distribution customers at all, unlike AMIA. They would be supplying themselves, and they would be managing their wholesale market transactions completely in their own right. Nobody would be interfacing for them, and they would be wheeling their power over lines that are owned by Velco and would not be availing themselves of the distribution facilities that GMP has. So on its face, in that sense, it's a case of first impression. and it'll be for the PUC to decide whether that passes muster or not, if that helps, Senator.
So the Marble company there used to generate electricity and sell it.
Indeed.
But IBM never produced electricity for sale. So what is a virtual utility? What's a virtual generator? I mean, I don't understand. I'm trying to understand what's.
Quite so. I mean, I think what you're left with is returning to the definition of a utility under Vermont law. I'd have to go look that up.
Okay. Thank you.
And the question becomes, do they pass muster under that or not? And that's what the PUC will decide.
Or
Okay.
in the case of appeal to courts, right?
Indeed.
Yeah, okay. Yeah. So thank you.
Right. It's whatever, horse of a different color, right? Not generating, no customers. So that is, and I think the Omnia case, because inherited that generation capacity by purchasing Vermont Marble Company, which had been sort of a vertically integrated industry, right? Generate their own power, they had excess power, so they had customers, but
Indeed.
they were much more utility. They were like a marble company and a utility sort of rolled into one, but coming at it from a different angle. All right. So I know we're about to lose the commissioner. Any more questions for the commissioner before she has to leave? Right. Great. And I think, so my understanding is, Mr. Porter, you're like the case manager or something like this for the department. So can you help us understand what steps you'll go through, sort of and on whose, and in a way sort of on whose behalf as you chase this down?
Mr.
Thanks.
Chair, as a point of personal privilege, may I just say that Mr. Porter's the public advocate.
Public advocate.
He is advocating for the public on this matter, and his staff of attorneys are working on the case with him. He's not just a case manager.
Well,
So.
I knew I had the wrong term. I'm
Okay.
sorry if I've
And on
insulted
that, not at all.
the public advocate.
On that picky note, I'm going to drop out, so you'll have a much freer conversation.
All right.
And I hope you'll feel free to have me back if I can be of further help to you.
Thanks very much.
Absolutely.
All right. So, Mr. Porter, as the public advocate, and thanks to Commissioner Tierney for the correction. All I meant was that this thing's in your wheelhouse, and I figure you're going to be sort of chasing down every part of this case on behalf of a variety of partners. I'm thinking, so if you could correct me, like, do you represent not only ratepayers, but the other utilities
Sure.
as they would be impacted, et cetera?
Sure. So, and I take no offense at the description. I've had much worse descriptions. No, but fundamentally, just to start with, this petition comes in the door, if you will, and obviously this case is kind of a big deal. It's, what are they, 7-8% of the load in Vermont. They're a huge Green Mountain Power customer, and so just. And I think you all know this, but the department is a statutory party before all proceedings at the Public Utility Commission. And ultimately, as this petition is before them, they will make a decision. But as one of the parties, the department will provide testimony and will make a case. Ultimately, and there will be an evidentiary hearing. And so the way it works internally is, the department is made up of more than several divisions. I'm the public advocacy division, which is the lawyers. We have econ and finance division, an energy planning division, an efficiency division, and the electrical engineering division. All of those divisions will actively participate in this proceeding, and will ask discovery questions and then formulate testimony. So in this case, there's really kind of two areas so far that are, I think, warrant a great deal of consideration. The first is, this is Green Mountain Power's largest customer, And so how will there no longer being a Green Mountain customer affect ratepayers? And some of you have heard me say before, if Global Foundries, turned off the lights tomorrow, I think we would probably see an immediate rate impact to the other GMP customers of 2-3%. So one thing that we'll be looking at is to make sure that the ratepayers don't suffer as a result of this transaction. And then the other things that we'll look at are the energy policy components, as I think Gene mentioned earlier. And certainly, I think the law is clearly, as it stands today, applicable with greenhouse gas reductions. And where it gets a little more complicated is with some of the res things, certainly say tier 2, tier 3, which are really geared for more retail type customers. And so I think that will be kind of the other big piece that we'll be looking at, and how to deal with that, and then how to ensure that this new entity, which will be subject to certain obligations, will be able to fulfill those obligations. Does that help at all?
Yes, yeah, sure. It's good to be reminded of the different divisions you have and how you, the different analyses you bring to the table. And let me pause and just see if there's committee questions. There are some, novel things about this that, I can see how if it's claimed that there are no customers, then there's something peculiar about that, because somebody's consuming the power. It's not being purchased for banking, so if there's no customer, it's a little hard to figure out what that transaction's all about. And then if you look at it from a customer perspective, it's usually customers that have their obligations fulfilled by their utilities, and for instance, the RES, or taking a share of standard offer power, things like that. So I think it's definitely a unique, a new flavor of utility, and how this operates, I guess, besides the legal questions, I think it is, I'll just say, of some concern to me that we would consider 10% of the load in the state being cut loose from various energy policies that are all oriented to reducing consumption, reducing greenhouse gases, et cetera. And it may be that under the new operating entity that they would meet or exceed current state performance standards. But right now, I don't see anything that assures me that that's going to be the outcome. And then we have the question of, to what degree do we support as a state, not this committee, but to what degree do we support as a state any entity sort of stepping out from the state's own goals and objectives around the harm of greenhouse gas emissions, for instance. So, and I guess, can you say something about, my sense would be, even if this were to move forward, I'm asking you to speculate, so maybe this is a dead on arrival question, but a CPG is almost always issued with terms, correct? They're conditioned.
Conditions.
So even if Global Foundries power division didn't operate in exactly the same way as the other utilities in the state, it might still have obligations expressed in a certificate of public good. Is that a possibility?
Absolutely, and I think it's likely, and I know you said that the committee was going to have the petition posted where you can see it. I think Global Foundries anticipates that, as I've said many times, in any large, I don't remember a large transaction that escaped conditions. And I think they are, if you just look at their petition, they're aware of the greenhouse gas emissions and all of the other obligations. And I think they certainly would expect there will be asks made of them, certainly from the department and others, as this process goes through. They have not filed a petition that says we're putting up a virtual 4 walls around our campus and we're not participating anymore. As I say, when you look at the petition, I think you'll see that they anticipate that that's will happen.
Sure. Well, and so we're speaking about Global Foundries, so maybe let me turn back to Mr. Reeder. I'm not putting you on the spot, but I did want to give you an opportunity to respond on that point, which I think is probably the basis of the interest and concern of this committee, because of our work on energy policy, which has 2 orientations. One is helping Vermonters save money, the efficiency side of things, and then what goes hand in glove with that is reducing emissions by virtue of using less energy and by virtue of using cleaner energy over time. So I don't know if you want to respond to that or just, let the petition process roll forward.
No, absolutely. And thank you, Senator Bray, for letting me respond to your question. And it is detailed in our petition, which, I will forward to this committee. But I want to reassure everyone on this committee that Global Foundries is committed to greenhouse gas reductions. In fact, our corporate policy aligns with Vermont's energy policy, which emphasizes the reduction in greenhouse gas emissions. In fact, between 2019 and 2021, in its corporate goal to journey to zero, our goal is to, from a worldwide standpoint, to reduce 18% of Global Foundries' carbon emission worldwide, which was normalized on the 2018 baseline. What that 18% means, it's about 12,000 metric tons of carbon equivalent worldwide. So what does that mean for Fab 9? Fab 9, that goal actually is 3,200 metric tons of carbon equivalent. And to date, in the last 2 years, we have met 1,700 metric tons per carbon equivalent reduction in global greenhouse gases. And we do, in fact, believe that we are going to meet that goal of 3,200 by the end of 2021. So with that being said, during that 4-year transition period, we will be meeting all of the clean power procurement through Green Mountain Power. However, what we'd like to do during this period is create a more holistic approach to include the following: not only the greenhouse gas reductions on all platforms, but I mean all platforms, not only our power supply portfolio, but also our heating emissions. In addition, we also like to expand the present energy efficiency program that we're actually using today as part of SMEEP. In that energy efficiency projects, we will continue with that, and we will continue investing $1 million annually for the next 3 years, and still submitting reports to the department on those energy efficiency goals. But again, we'd like to expand that also to look at peak shaving opportunities. For instance, an example could be battery storage. And then from a holistic viewpoint, develop a cost competitive clean power procurement as we enter into 2026. And that report will be shared and given to the Public Service Department / PUC for review. Does that help answer your question?
Sure. Thank you very much. That was helpful. Senator McCormick has a question.
Thanks. Yeah, this this is sort of a new issue to me, and I don't really have an opinion on it. As starting to just to educate myself, how many employees do you have?
At the plant right now, in Fab 9 is about 2,200 employees. Worldwide,
Okay.
Global Foundries has roughly 16,000 employees worldwide.
Yeah, I'm not just thinking in Vermont about 2,200.
2,200 in Vermont, that's correct.
Okay, so that's comparable to a small town in Vermont. Bethel, I think where I live, Bethel has about that many. I think Ludlow has a few, but there are towns in Vermont that have their own utilities. I'm wondering if the populations are comparable. I'm just thinking if this is the argument. As I say, I actually have. I'm not being coy. I have no opinion on this. It's too new to me. I'm trying to educate myself just to get started. This is not. It doesn't strike me as an outrageous idea. I guess I'll just leave it at that.
Yeah, Senator McCormick, and if I can comment on that, when we look at Global Foundries, the Essex facility, we actually consume more power than the entire city of Burlington. So even though the employee population in Burlington is much larger, we're still consuming more power than the entire city.
Yeah, Ludlow, which I represent, I think has its own power company too. Okay, thanks.
Thank you, Senator McCormick. Mr. Porter, I asked a couple of questions. I just want to make sure I didn't leave. We went to questions. I don't know if there's anything else you had wanted to say that you didn't get to yet before we go to our own council to talk a little bit about the legislature's possible responses.
Sure. And just one other thing I would say about the process is in these PUC proceedings, we do have interveners. Several of the other utilities and VIPSA have intervened. I think I saw this morning that All Earth Renewables have made a motion to intervene. So I think that all of these things that we're talking about are going to be well represented kind of, and it's going to run the gamut, I think, from the positions that come into this case.
Okay, great. Senator McDonald?
So I'm still kind of stuck on this business of what a virtual utility is. We once dealt with the problem of the challenge of banks, where we had banks, and then we had this proposal to have and this is the vocabulary that was used, non-bank banks. And a lumber company could be a bank, or you, Senator Bray, you and I could be a bank. But in order to create these, the law had to change because banks were defined. So I don't know what a virtual utility is. We have definitions for utilities. And I don't know what the definition is. So that's what I'm trying to grasp here. And Mr. Reeder has shared with us things that his company does and that other companies do in trying to meet our greenhouse gases. I'm trying to understand how we have a non-utility utility without a statutory change. And
so, Mr. Porter, I don't know if you have anything more you want to say. That does sound like a question maybe for our council. And in that way, it would be a perfect segue, Senator McDonald, to hearing from Ms. Schakowsky. So I don't, Mr. Porter, do you want to take a swing at that before we go to council?
I think I'm going to let Ellen give it a shot, and I'll come in after. How about that?
Yeah, right. Well, that's a very wise batter.
The only thing I would say
that
I can't help myself is in their petition, Global Foundries is calling this an independent self-managed utility. And I know we talk about virtual utility, but it will be a legal entity. If it's approved, it will become a legal entity with a CPG. And the virtual piece, I'm I don't exactly know if that's just something that we're calling it that maybe is inaccurate. I don't know, but I think I'll let Ellen.
If something is going to become a legal utility, and either it is one or it isn't one, or something has to change to make it a legal utility. So some
That sounds like-
statute has to create the legal environment for it to be a legal utility, and I'm trying to find out what that is.
Well, that sounds like the perfect existential segue to our own counsel, to who's been looking into this on our behalf. So just to frame up a little bit, and we can schedule one more time and come back to this, but I had asked Ms. Schakowsky to help us on two things. One is the petition specifies the roles and responsibilities of the new so-called self-managed utility that make it unique compared to other utilities. So I was just trying to asked her to help us understand in what ways this is or is not like other utilities that exist today. And then the second question is, when matters like this are before the PUC, what are the possible responses of the legislature? What's appropriate? What's allowable? How might we be involved, or might we simply wait for a ruling to come out? So those are the two things. Ms. Schakowsky. Good morning.
So this is a very interesting situation. Title 30 is called public service. The Public Utility Commission and the Department of Public Service have jurisdiction over public service corporations. And in much of Title 30, the word utility is not used. And that, I think, is the actual crux of the issue that Senator McDonald has identified. There are definitions of utility in Title 30, but the general, for example, in 30 VSA Section 2, the statute that gives the Department of Public Service its jurisdiction, it refers to public service corporations and refers to utility service. So it's complicated. I think what's going on in this instance is that a party is making a legal argument in a sort of gray area. I think the word utility here is confusing because there is a general understanding of what that word might mean, but there are different definitions. So that's there are multiple definitions of public service corporation or utility in Title 30, and then there's also a definition in the PUC rules of utility. So yeah.
Okay. Well, can you fill us in a little bit on there were two things that I had asked about ahead of the meeting. One was, in what ways does this petition seek to, I guess, it sounds a little negative, but exempt itself from current utility law? There's some very specific requests in the petition that help highlight in what ways the proposal sees itself as creating a unique entity. So could you talk to us a little bit about that? Like, Senator Campion before we go on?
Oh, well, I'm not clear again, and perhaps Ledge Council is still working on this, trying to understand whether or not the legislature has a role in this process. And I'm sorry if I missed that, Ms. Chakowski.
No, that's question number 2 was just one I wanted to help us understand the petition and what's being proposed. And then 2, what do we do about it? Is it just to understand, or might we in some way be engaged in the whole process?
Sure. I think it would make sense to address Senator Campion's question first.
Sure.
So this is a contested case before the Public Utility Commission, a quasi-judicial entity. So there is an ongoing proceeding. So the legislature may not have a direct role. The PUC needs to go through its process. However, there is the ability of there's the ability of the public in general to participate by providing public comments. And in the past, legislative committees have sent letters during the public comment period raising issues they would like the Public Utility Commission to review. Also, there is an interesting sort of precedent in 2007, when Fairpoint was interested in purchasing Verizon's assets in Vermont, there was a session law passed. There was a piece of session law that was passed that directed the legislative leaders to also specifically send a letter to the Public Utility Commission, weighing in on the legislature's position. So, and I have reviewed that letter, and it did lay out a number of legal arguments that they wanted the Public Utility Commission to consider when evaluating whether or not to approve Fairpoint's purchase. So there does seem to have been multiple instances where either individual legislators, committees, or the legislative leaders, including the pro tem and the Speaker of the House, have sent letters to the Public Utility Commission regarding an ongoing proceeding. In addition, there is this issue about definitions. So any amendment to a definition, so you are the legislative body that has supreme legislative authority to amend laws. If for some reason this committee saw an issue with the laws as they stand, you could craft legislation to address your concerns, knowing that this is an ongoing proceeding and that it can't, there are restrictions on the implications for ongoing proceedings. So, but in the future, legislation can be crafted to address future situations or, potentially things in that area.
Senator Campion?
So this sounds like, at this point, since it is an ongoing, it's in a process right now. There's nothing that we can do, nor sounds like we should do, to interrupt that process. But I might be putting words in your mouth, and I just want to make sure. And then later on down the road, if this committee or the legislature wants to do something, in a way, it's reminding me of the Adirondack. Something's happening right now. We can letting that process go forward. This committee is certainly interested in knowing information, and going forward, if we want to do something, we can do something. But right now, it doesn't sound to me like it's in our jurisdiction. In fact, if we were to bring it into our jurisdiction, it could interrupt a process that's already underway. Thank you.
So
Chakowski.
I do think it is similar to the Adirondack, except for currently there's a different stage of the process going on right now, right? So the permit hasn't been issued. The agency is reviewing the permit application. And so while I do not recommend that the legislature try to stop that would be not a great idea. Right. You could potentially, a member or multiple members could send public comment letters to the PUC, raising specific legal concerns they would like to at least be considered as part of the process.
Sure, and so if one of us were to work on this and believe it's important, people could always find signature, find support, or again, we let the process go. Okay, thank you.
I mean, I think, so let me check with council. The distinction I see that's critical, not just important, is that the Adirondack, we got it after the permit was issued. And so it was a done deal, and then that would have been problematic to try to interfere with that in any way. But if there's an open process in which we can be engaged, if we are interested, then I think then we're sort of, it's an opportunity to participate without disrupting. I guess that's the distinction I would make. I don't know who's interested, but as you say, anyone who's interested could file a petition as a citizen of the state of Vermont if you're already a ratepayer who's impacted.
Right. So yeah, I guess just to close, I mean, knowing that morning committees on Friday, I don't know if I could get to I don't know I guess I'm looking to the chair. You're not looking for us to work on drafting a letter over the next 3 or 4 days, taking a lot of testimony on this, or is that what you're planning on?
No, I'm not planning on.
Thank you.
On that.
Great, thanks.
Just wanted to, but I did want everyone, we're going from 0 to 60 on this topic. And so I wanted people to know everything from there's a petition coming in, what some of the issues are, what the process is, if you have any rights or ability to participate, and if so, how. So with that, maybe sort of going back to one other quick thing, given the, Ms. Schakowsky, I don't know if we want to ask you to walk through what the petition, being an application of sorts, right, to create this utility, makes some requests in terms of how it would, what parts of current law will and will not apply to it.
So we said that utility was not defined in law. So to walk through to understand creation of what?
So
A self-managed utility.
So the petition before the PUC is a Section 231 certificate of public good. So a regulation of a corporation that is within the PUC's jurisdiction. So Section 231 of Title 30 establishes that certain corporations are within the Public Utility Commission's jurisdiction. And so that is the process that they are seeking. And all of the utilities, I believe, in Vermont have a 231, but other companies also have 231s, including some of the batteries, the energy storage companies have sought 231s. And then there are some other examples of smaller entities that are not utilities, but they are within the PUC's jurisdiction because they meet the language of the statute. So
I'm net metered. I have a net metering facility. Am I in that group?
do you have a 231? So
I have a certificate of public good set at 231.
no, so there are multiple
Okay.
different kinds of certificates of public good. There
Okay.
are, so in addition to 231, there's also Section 248. There's also Section 248A.
I'm sorry, I shouldn't have interrupted. Why don't you continue on the direction you were going there?
Yeah, so there are different kinds of certificates of public good. The PUC goes through the analysis. And so one of the things, I'm not completely prepared to walk through the actual language of the petition, but I was going to just flag that they're seeking something called de minimis regulation as a an entity within the PUC's jurisdiction. And this is something that the PUC has done and has established criteria for. And it is a process that essentially says, I am an entity that is within your jurisdiction, but I do not rise to the level of, I may not rise to the level of jurisdiction that full utilities require. So I should be exempt from some of the statutes in Title 30 that regulate corporations. So on the list in the petition, de minimis regulation would exempt the entity from Section 204 of Title 30, 209, 218, 218C, 219, 225. Also, the language of Chapter 89, and to provide notification of utility power supply transactions to the Commission under PUC Rule 5.200. So many of the first sort of handful of those are the sort of day-to-day actions that the PUC regulates. Section 204 is the requirement that they file copies of association or a copy of certificate of paid up capital stock. 218 is the rate setting requirements. 218C, the requirements of least cost integrated planning. Section 219 is the duty to serve the public and reasonable rates. 225 is the duty to file rate schedules. So these are things that regular utilities are required to do, and they are asking to be exempt from them and only comply with the de minimis regulation. So a lighter amount of regulation and oversight by the PUC. In addition, so the other thing I wanted to talk about quickly, which is another definition issue, is the duty to comply with the requirements of Chapter 89 of Title 30, which is the renewable energy chapter. So this is one of the other issues related to definitions. So Chapter 89 contains the language on the renewable energy standard and the 3 tiers, the standard offer program, and the baseload renewable power portfolio, which is the Rygate facility. So if this CPG would be granted, it's likely that GlobalFoundries would not need to comply with the requirements of Chapter 89 because the definition at the beginning of that chapter is, the defined term is retail electricity provider. And so that means a company that is engaged in the distribution or sale of electricity directly to the public. So by definition, GlobalFoundries would not meet that definition and therefore would not necessarily need to comply with those statutes as currently defined. So I did want to flag one thing. In my review of this, in the legislative history on this term, I came upon something interesting. So this term is different than some of the other terms in Title 30. It is specific and does specifically mention sale to the public. So in crafting that definition in 2005, IBM was interested in crafting the definition specifically so that it did not apply to them. Because at least reading of the history on this was, at the time, IBM was exploring whether or not they would be able to purchase wholesale power directly. I don't know if that ever actually happened. I'm still looking through, but I know at one point IBM was interested in purchasing wholesale power directly. And at least part of the discussion on crafting this specific definition was to make sure they were not they would not fall under that definition and have to comply with Chapter 89.
Okay.
So that is a specific definition that perhaps you could look at in the future if you would like to change that definition.
Right. Great. Any last questions for Ms. Chakowski? All right. So thank you both for helping us know what's been requested in and out and why, the definitions issue, and the opportunities for participating or not. With that, we're going to have sort of an abrupt change of scene, and we're going on to talk about the universal recycling law. So thank you to our guests this morning. So Mr. Porter, Mr. Reeder, Ms. Chakowski. Before we go on, Senator Campion.
So, Mr. Chair, I'm just wondering, for anybody that inquires of us, is this is where we're at this point? This was informational, and we're leaving it there, if you will.
Exactly.
Thank
So
you.
for now, it's just information.
Thank
And maybe we'll have some further committee discussion, but for now, just information. Try to get everyone up to speed on what's happening.
Are we conducting oversight? Is that what we're doing?
I would say something akin to that. Yeah, sure. I mean, we want to be
Similar.
aware of what's going on.
Similar to oversight.
Yeah. And obviously the committee should take, people particularly interested members of the committee, I think, would find it valuable to read the petition from Global Foundries. So you'll understand their proposal in more detail. And then we can have some committee discussion about what further work the committee might do. With that, we need to swap over to talking about the universal recycling law and solid waste. Thanks, Mr. Porter. Thanks, Mr. Reeder. And hear from Michael O'Grady. We're having a hearing tomorrow, a joint House-Senate meeting, House Natural plus our committee. Hear versa about the universal recycling law. In particular, there are folks who are concerned about the way in which food residuals are being handled, the evolution of how we're handling food residuals in the state of Vermont. And to, I think, be just direct about it, there's a concern that some of the strategies for handling food residuals that involve depackaging may be adding contaminants to that food residual stream, and therefore may have unintended consequences from an environmental perspective, and in terms of how it does or does not meet the goals of the universal recycling law. So before we hear that testimony tomorrow, so we'll hear from composters who are interested in and concerned about how it's being interpreted. We'll hear from the department. We'll hear from a major a waste management company that is involved in depackaging already, as well as a facility that's going to be receiving that product. So we'll learn more tomorrow. But before we walked into that hearing, I thought it'd be helpful for us to just know the legal lay of the land that these different parties are interpreting somewhat differently. So with that preamble, Mr. O'Grady, good morning, and thank you for adjusting your schedule to be able to join us today before we wrap.
You're welcome. I do need to leave at noon. I have another previously. Okay. Do you want me to share the screen?
Yes, please.
did I do with it? Actually, do you know if it's on your website?
I didn't see
Yes,
it.
I put it
Oh,
on
okay.
when you sent it to me.
Okay. Can you see my screen?
Yep.
So generally, the universal recycling law is derived from Act 148 of 2012, and that required solid waste facilities, solid waste haulers, and the public to manage mandated recyclables, leaf and yard residuals, and food residuals separate from solid waste. You'll see the definitions of those key terms. Mandated recyclable are the traditional recyclables. Leaf and yard residuals are source separated, compostable, untreated vegetative matter. Food residuals are source separated, uncontaminated material derived from the processing or discarding of food, and that is recyclable. For solid waste facilities, you'll see how that was phased in for them to collect the different categories separate from other solid waste and deliver each different category to for the management and recycling of the item. There is the ability for facilities to incorporate the cost of the collection of mandated recyclables into their solid waste charges, but they may charge a separate fee for the collection of mandated recyclables, leaf and yard residuals, or food residuals. Then there's the requirement that public buildings and public land have separate containers for the collection of mandated recyclables wherever there is another receptacle for solid waste. Then you come to the provisions for solid waste haulers. This is the provision that's seen the most activity since 2012 when Act 148 was enacted. When originally enacted, there were requirements for solid waste haulers to pick up mandated recyclables, leaf and yard residuals, and food residuals. At one point, the requirement to pick up leaf and yard residuals was struck. At another point, the requirement for haulers to pick up food residuals was delayed from 2017, and then it was delayed to 2018, and then it was delayed to 2020. And then there was a amendment to say that they only needed to offer non-residential customers in apartment buildings with 4 or more residential units collection of food residuals. And they are not required to offer collection of food residuals if another commercial hauler provides the collection services in the same area and has some sufficient capacity to provide service. There are a couple of other exemptions in 2 and 3, and then you get to the provision that they may not charge a separate line item fee for the collection of mandated recyclables, but they may charge a separate fee for the collection of food residuals. And then you get to the problem that's going to be part of the conversation tomorrow. When Act 148 was enacted in 2012, there was a policy statement about how and the management hierarchy for food residuals that were collected. Before I go into the hierarchy, you need to remember that when this was originally enacted, there wasn't a requirement that everyone manage their food residuals separate from solid waste. It was phased in, and even the phase in had a provision in it that said you didn't need to separate if you were not within 20 miles of a facility that would accept and had capacity to accept your material. So with that in mind, these were probably never as enacted considered binding. So you'll see that the first priority was to reduce the amount generated at the source. The second is diversion for food consumption by humans. Third is diversion for agricultural use, including consumption by animals. Fourth is composting, land application, and digestion. And fifth is energy recovery. So those are, it's a policy statement about how the state wants to see these food residuals managed. Then you will see the requirements for separation, how they to separate it from other solid waste, and arrange for transfer to a location that manages, or they manage their own food residuals on site. Then you'll see the phase in for the different sized generators, culminating in the July 1, 2020 date, where any person who generates any amount of food residuals must arrange for their transport and disposal or manage on site. And then last, you get the landfill disposal requirements. It is now prohibited to dispose in a landfill mandated recyclables, leaf and yard residuals, wood waste, and food residuals. Provided that the disposal ban shall not apply to mandated recyclables, leaf and yard residuals, or food residuals collected as part of a litter collection event. So when it's green up day, the people that are out there collecting roadside debris don't need to separate everything from the rest of the solid waste. So I think this is probably what's going to be the focus of your discussion tomorrow. It's the hierarchy and whether or not the depackaging of discarded food that's still in its packaging needs to be managed according to this hierarchy, and whether or not it's being done appropriately so.
Okay. Ken, on the prior page, there was the phrase source separated you had highlighted. Can we just go back to that, and can you explain how source separated does or does not apply to here's an example of what a concern I heard expressed, that there had been, for instance, grocery stores that were taking food that had gone by that was in plastic clamshells, and they were opening those containers, putting the food into a food residuals bin, and the plastic went into a recycling bin. But that now some of those same food that's gone by wasn't being separated at the source, that is the store that was passing these materials on, a grocery store. They were leaving the food in the container. It was going into a stream, into a system that then depackaged it mechanically, and that some of that clamshell material ends up with the food residuals. So I'm just wondering if you can say something about, is there an obligation to separate the food from the container in this case, it was, the person was highlighting a grocery store as the source.
So there is a definition of source separated in Act 148. It's separation of compostable and recyclable materials from non-compostable, non-recyclable materials at the point of generation. So then you go to the requirements for generators, which is they shall separate food residuals from other solid waste, provided that a de minimis amount of food residuals may be disposed of in solid waste when a person has established a program to separate food residuals, and the program includes a component for aeration. So there's there is a requirement for the generator to separate from other solid waste and from the non-recyclable, non-compostable materials. So does that answer your question?
Almost. Sorry, I'm just catching up a little still here. So the generator in this case, so I'll just stick with the grocery store. Does the grocery store have an obligation before the materials leave their facility to take that food out of the plastic packaging and put the food into a bin and the plastic packaging into a separate bin? Is that what source separation is?
The law doesn't provide that specific detail or specific requirement. So it is subject to interpretation.
Okay.
And I would focus on the source separation definition. There's an argument that they don't have to take it out of the packaging if the packaging is recyclable or compostable, because it means separation of the compostable and recyclable materials from non-compostable, non-recyclable materials. So if somehow the package is recyclable or compostable, they arguably don't have a requirement to remove it.
Okay. So now I see. So in that case, that line that you were the definition line, it kept grouped together the food and the recyclable. They are treated as a unit in that definition, and they're distinct from the non-compostable, non-recyclable parts. So now I get where the line is drawn, which seems like that's part of where people are, what they're thinking about. And then how does the hierarchy, in what way is the hierarchy binding or not binding? I mean, you said something interesting, that it was policy, but not necessarily binding. So
that's an interesting component of law. There are policy statements in statute that are clearly not meant to be binding and are either hortatory statements or just persuasive. And my favorite one is the one in Title I. It's like 825 or something like that. That says that government needs to work together. All branches of government need to work together. I'm like, that's clearly not binding, right? It's a hortatory statement. But there are other policy statements in law that courts have interpreted to be binding, to not be just persuasive, but to be determinative. And so you have a broad array of policy statements in law that a court, that it's subject to interpretation. And there's been court cases that have found that policy statements that might look persuasive or hortatory and non-binding are binding. Probably the primary example of that is the groundwater public trust policy statement. It said that groundwater should be managed as a public trust resource, but that it doesn't create an independent cause of action other than for quality. Other than for quantity, I'm sorry. And the court said, well, no, it has to be managed as a public trust resource. That was the legislature's intent. And there is an independent cause of action. And there is a requirement that the agency implement the public trust protection throughout all regulatory programs that have an effect on groundwater. That's what the court found, so you have opportunity for interpretation by courts of policy statements. Some are just clearly you can't, and the courts have found that they're clearly just they're not binding. Probably the clearest one is the constitutional provision that says officers of a government are accountable to the public. And the court said, well, Yes, but how do you enforce that? That needs to be enforced through statutory provisions that are created to maintain the accountability of public officers. And so that's what led to the open meeting law, the Public Records Act, all the other accountability provisions in law.
And I know that you have a hard stop, so I'll just be really brief. This language 4A seems a lot like, something clear and directive, shall be managed according to the following order of priority uses, and then it's 1 through 5 in a numeric order. So I'm trying to understand how something that directive doesn't seem directive.
Because you have to understand that there's a lot of law that's built into all of these uses. So the reduction of the amount generated at the source, how do you mandate that? Food should not be diverted for food consumption if it's post-consumer or if it's expired, right? So then you go, can it be diverted for an agricultural use, including consumption by animals? There's a significant amount of law regarding feeding pre and post-consumer food residuals to animals, including in Vermont, that if it's a commercial feed, it needs to be registered with the Agency of Agriculture. And then composting, land application, and digestion. Well, land application of waste is the disposal of waste. It needs a permitter to be authorized by ANR. Composting is subject to significant requirements in the state, including potentially having a composting facility certification. Digestion also needs significant licensing and permitting, especially if it's connected to the grid. So it seems determinative, but there's a lot of things that might not allow for the food to be used for consumption by humans or for agricultural use or for composting, etc.
Okay.
And I do need to go now.
Yeah,
that's okay.
I see our time is up. So thanks so much for jumping in. And this is going to be very helpful background before we go into tomorrow's hearing. Thank you, Michael.
You're welcome. Bye.
All right. So thanks, committee. Sorry that we went over by 2 minutes.